we have a fair number of attendees, and it is 2 minutes after the hour. So good afternoon, everyone. Here in the district, and I want to welcome everyone today to our third in our FOIA webinar series, Record Redaction and Commonly Used FOIA Exemptions. During the presentation, if you have any questions, please either during or at the end, raise your hand in Teams during the WebEx, or put your question in the chat. That way we can get through the presentation and address questions at the end. I'll be assisted today by the Office of Open Government Chief Counsel, Johnny Barton, and our IT specialist, Mr. Kevin Brown. So again, please put into the chat, which I won't be able to see while I'm presenting, any questions or comments that we'll address at the end. Let me make sure that everybody can hear me. Chief Counsel Barton, can you let me know if everything's good with the microphone? Good. Okay, thank you. All right, so today we're going to be covering the following 6 areas. First, we're going to talk about record redaction in terms of identifying and obscuring privileged information. Then we're going to discuss commonly used FOIA exemptions here in the district. We'll start by talking about the 2022 FOIA report, which details DC's comprehensive activity. And then we're going to talk about the 4 most common exemptions, those being trade secrets, personal privacy, law enforcement, and agency communication. Let's start with record redaction. This has been referred to in our earlier 2 webinars. So you're probably familiar with this, but especially for our newer FOIA officers, we want to do a little bit of a coverage. So in terms of producing the records, reasonable redaction. So the record can only be withheld in its entirety if your agency or the relevant agency determines that the record can't be reasonably redacted. So the document has to contain parts that are protected by one of the privileges and parts that are not protected. And the existence of the privileged parts, meaning the stuff that is blacked out, redacted, can't be used to justify withholding the other parts. DC Official Code 2-534B states, that any reasonable segregable portion of a public record shall be provided to any person requesting the record after deletion of those portions which may be withheld from disclosure pursuant to subsection A of 2-534. So in every single case, the justification for the deletion has to be explained to the requester, complainant, etc., fully and in writing. And the extent of the deletion has to be shown on that portion of the record, that is provided to the complainant or the requester, unless indicating that indication would harm one of the interests protected by the exemption. So, where technically feasible, the extent of deletion and the specific exemptions should be shown right there at the place in the record where the deletion, redaction, blacking out was done. So questions to ask yourself when redacting. First question is, are you withholding an entire record? We just spoke about that. Are there parts of the record that are not exempt? Meaning there's nothing in any of the sections or subsections that provides the FOIA officer a legitimate basis to redact, certain parts of the record. And then the third question is, if you remove the non-exempt portions, is the document still legible? So first question, are you holding the entire record? You asked, did you find responsive records in your search. If there's nothing, then you're not withholding a record. You are not required to provide something that does not exist. And then, is the requester receiving everything that you did find if you found something? So if the requester got everything you found, including nothing, then you're not withholding an entire record. The second question, your agency is withholding an entire record. What's the basis? Why are you withholding? And so if you were to randomly pick any part of that record, would the basis applied be applicable to that part of the record? If yes, if your answer to that question is yes, then it is proper to withhold the record in its entirety. But if not, then you should be redacting those privileged or exempt portions and producing the record with the proper notations on the document that shows where and to what degree the redaction occurred. Now, if the reason of applying the basis is personal privacy, then you ask, does the entire record raise privacy concerns such as a tax return or only parts? Where, for example, an email that is entirely about a work issue, however, that has a PS at the end concerning that individual or one of the individuals in the email chain having a medical procedure. Those are two separate things. A tax return would have very little in the filled out fields that might not implicate a privacy concern. But the work email and the postscript about the medical procedure are easily separatable from each other. So if the record contains non-exempt content, you have to produce that non-exempt content. Are portions of the record not exempt? The question there is, are you withholding due to, for example, attorney-client privilege? And is all of the document embraced by attorney-client privilege? Or was some part of that communication at any point shared with a third party, in which case we all know attorney-client privilege no longer would apply to the shared with a third party component. Is the reason deliberative process? So again, one of the exemptions we're going to talk about more fully here in a moment. If it's a deliberative process exemption, does the entire record raise privacy concerns? Again, such as the tax return or only parts? And then, is the entire document part of the deliberation or are parts of it just statements of already established policy? And what we're going to discuss going forward is there's a difference between deliberative process and final or established policy. If it's final or established policy, it cannot be redacted. But if it is legitimately part of the deliberation process, then it can. It can be redacted. Does the document contain purely factual information, such as charts and graphs, and was the record shared again with a third party? Those are things that have to be considered, have to be contemplated in terms of making a redaction decision. Are parts of the record now not exempt? So are you withholding due to a commercial interest? And again, the issue is, would release of the entire document cause harm to a commercial interest, or would only the release of, say, something specific like dollar amounts, proprietary formulae, things like that, cause the harm? And again, at that point, you have to do the segregation, and you have to, in fact, redact only those portions that are subject to the exemption. If you remove the exemption portion, is the document still even legible? So non-exempt portions of a document must be disclosed unless they are inextricably intertwined with exempt portions. And that came from the DC Circuit's opinion not quite half a century ago, Meade Data Center. And the link here in the slides, which will be available as well as reporting following us getting wrapped up today. So in case that question hasn't already been asked, I want to go ahead and address that and just let you know you will be able to access this material and follow these links. Question: if you redacted all exempt portions, would you be looking at a wall of black ink? If so, then there's no point in engaging in redaction because you're not producing a responsive document. You're not producing anything in terms of what the requester is looking for. They're not looking for black ink. Are there paragraphs or pages that would not be exempt? Here, however, if there are, reasonable amounts of information that would be visible, paragraphs worth or pages worth, that would not be exempt, then you do redact and you release to the requester. Let's talk about scoping for a moment. Once you've identified a responsive record, can you redact the information within the record that is non-responsive? This is what is known as scoping. So once the government concludes that a particular record is responsive to a disclosure request, the only basis, the sole basis on which it may withhold particular information within that record is if the information falls within one of FOIA statutory exemptions. And again, that's a much more recent circuit opinion, American Immigration Lawyers, the Executive Office for Immigration Review. So what does this mean for you? That discrete information within a responsive record can't be redacted on the basis of non-responsiveness. It can only be redacted if one of the specific statutory exemptions apply to that discrete information. Okay, so that's redaction. We're now going to talk about the DC most commonly used FOIA exemptions based on agencies in the district in the 2022 report. So DC Official Code 2-538A requires that each year the mayor requests from each public body and submits a comprehensive FOIA report to the council covering record disclosure activities during the fiscal year. So we're going to go on the basis of the 2022 report, total FOIA requests, exemptions that were used over 300 times, and then the agencies with the highest requests. So for the 2022 FOIA reports, here again is the link to the 2022 FOIA report at the Office of Secretary's page. So for 2022, the total number of FOIA requests was 11,522. That's up from the same time the year prior, which was 9,655. Agencies that had the highest number of requests, you can see, and I don't think anybody's going to be particularly surprised at which agencies had the highest number of requests. Leading in at over 2,000 was MTD. Close, or not close, but second was Fire and Emergency. And then a close third was DCRA, which now is, of course, Department of Buildings and Licensing and Consumer Protection. But you can see the numbers vary significantly between agencies. These are, and again, not surprisingly, the most frequently used DC FOIA exemption. Exemption 1, trade secrets, 458. Exemption 2, personal privacy, always, I think, perennially the number 1. Exemption 3, law enforcement exemptions, coming in second at 1366. And number 4, agency intra or inter communication at 302. So exemption 1 is about protecting trade and commercial secrets or financial information obtained from someone that's privileged or confidential. Exemption 2, the personal privacy, protects information about individuals when the disclosure would constitute a clearly unwarranted invasion of personal privacy. And we'll talk about those fine distinctions. Exemption 3 protects certain investigatory records compiled for law enforcement purposes, including the records of counsel investigations. And exemption 4 protects inter or intra-agency deliberative and pre-decisional materials, again, for a final decision, written as part of the decision-making process in DC agencies. So, for all but I assume the most recent FOIA officers, most people I think realize that DC FOIA was modeled on the Federal Freedom of Information Act. And again, when you're looking for that specific site for a brief or something, it's in Barry v. Washington Post. So accordingly, anything that construes the federal statute are instructive and can be examined to construe the application of DC FOIA. So that comes out of Washington Post, the Minority Business Opportunity Commission, where the language is identical. So again, that's a key thing to bear in mind, where the language is. So the first exemption, trade secrets. To withhold responsive records under Exemption 1, the agency has to show that the information, 1, is a trade secret or commercial or financial information, 2, was obtained from outside the government, and 3, would result in substantial harm to the competitive position of the person from whom the information was obtained. And that's in 2-534A1. To withhold responsive records under this exemption, you have to show the information is, as I said, those three things, those three prongs. The circuit has defined a trade secret for the purposes of federal FOIA as a secret commercially valuable plan, formula, process, or device that is used for the making, preparing, compounding, or processing of trade commodities, and that can be said to be the end product of either innovation or substantial effort. That's a mouthful, but a secret, a commercially valuable plan, a formula, a process, or a device. So methods, ideas, things. The circuit's also instructed that the terms commercial and financial are used in their ordinary meaning relative to federal FOIA, and thus, in all likelihood, when you're construing DC FOIA. The exemption's been interpreted to require both a showing of actual competition and a likelihood of substantial competitive injury. So again, you've got to show both actual competition and a likelihood of substantial competitive injury. Again, the question becomes, when does information provided to, we're saying federal, but again, we're construing this for DC FOIA as confidential. Let's talk about that. Supreme Court held that information is confidential and protected if the information is customarily kept private, or at least closely held, and where the receiving party provides some assurance that the information will remain secret. Now, this guide, this handy rubric, relates to federal exemption 4. But again, it will be useful, and then we'll talk more specifically about DC FOIA. First question, does the submitter customarily keep the information private or closely held? If not, it's not confidential. If, on the other hand, they do keep the information private or closely held, then you move on to the second question, which is, did the government provide an express or implied assurance of confidentiality when the information was shared with the government? Again, if they didn't, you move on to the next question. But if yes, if the government provided either express or implied assurance, then the information is confidential. But if you said no, there was no express or implied assurance, you go to question 3, which asks, were there express or implied indications at the time the information was submitted that the government proactively would publicly disclose the information? So again, if there were no express or implied indications, then the information is confidential. On the other hand, if the government is silent, you go to the submitter, i.e. the source of the information, and you look at their routine practice, and that will be by itself sufficient to determine whether the information is confidential or not. On the other hand, if there were express or implied indications at the time the information was submitted that the government was going to disclose it, and you say, yes, that's true, and there were no other countervailing factors, then the submitter of the information could not possibly have expected the information to be treated as confidential because they had either an express or implied indication when the information was submitted that the government was going to publicly disclose. And again, a handy link to the DOJ step-by-step guide determining if something is confidential. Moving on now to personal privacy, to exemption 2. information of a personal nature where the public disclosure thereof would constitute a clearly unwarranted invasion of personal privacy. DC FOIA exempts the release of pre-sentence reports, academic records, mental health assessments, and other records pertaining to prison inmates' application for minimum sentence reductions. There's the case at that site. DC FOIA exempts personal information of public employees unless, and this is a big unless, the requester showed that the withheld information will shed light on an agency's performance of its statutory duties or otherwise let citizens know what the government is up to. And that's from a fairly recent case, Fraternal Order of Police versus the district. Talking again about federal versus DC. In terms of the privacy exemption, DC FOIA's exemption is much broader than that of the federal FOIA. Unlike the language in federal, which limits its, comparable exemption to personnel, medical, similar files, in DC, all information of a personal nature, the disclosure of which would constitute a clearly unwarranted invasion of privacy, is covered. This is essentially, a balancing test. When determining whether the exemption for personal privacy would apply to requested records, both DC FOIA and federal FOIA apply the standards set forth in DOJ versus Reporters Committee for Freedom of the Press, which requires that the government balance the individual's privacy interest against the public interest in disclosure. So a FOIA officer has to perform the balancing test. The individual's privacy interest in the material at issue has to be balanced against the public interest in disclosure, and this public interest has to serve the core purpose, quotes, of shedding light on an agency's performance of its statutory duties. That's from the same case. The Office of Open Government, our office, issued an advisory opinion OG 002.10.18.21. And this case was a request for public university records of faculty members. And the initial question was whether there was more than a de minimis privacy interest in the records subject of the FOIA request. The requested records were things like transcripts, hiring information, things at time of hire, things at time of promotion, etc. So absent more than de minimis privacy interest, the underlying principle of FOIA would require disclosure of the records. So it had to be established that the individuals maintain more than the de minimis privacy interest. And then if it's established, the next question is whether there's a public interest in disclosure that outweighs even the existing privacy interest. To establish a FOIA public interest in disclosure, the information sought has to serve, quote, the basic purpose of the FOIA to open agency action to the light of public scrutiny. When privacy interests are implicated, the burden is on the requester to establish that disclosure would serve significant public interest, and that interest must be more specific than having the information for its own sake. In this case, the office determined, the Director of Open Government determined that it did not outweigh, that the public scrutiny call did not outweigh the privacy interest of the two individuals, the two faculty members in this case. Here's a couple of case examples as well on the balancing test. In re-appeal of the Washington Post, the privacy interests of students and teachers under investigation for consumption of alcohol substantially outweighs the public interest in their identifying information. That was fairly strong language in that case. In re-appeal of Walter Thomas, the court held, you may disclose the names, professional qualifications, and work experience of job applicants who are successful, but you may also refuse to disclose other private information, such as home, telephone numbers and addresses, social security numbers, marital status, and personal references. And again, going back to the point about successful job applicants, You can also refuse to disclose any information regarding an unsuccessful job applicant, because clearly the privacy interest outweighs any public benefit, because they were in fact unsuccessful in securing a job with the relevant agency. The law enforcement exemption: interference with investigations, right to a fair trial, and personal privacy. So certain investigatory records for law enforcement purposes, including records of DC Council investigation, are exempt. It allows non-disclosure when disclosure would interfere with enforcement proceedings or investigations, deprive a person of a fair trial, constitute, again, an unwarranted invasion of privacy. We're going to talk about that in a minute. Disclose the identity of a confidential source, disclose investigation techniques, or endanger the lives of law enforcement officers. And that's in 2-534A3. And just for those playing the home game, the four most common are 2-534A1, A2, A3, and A4. So it's very easy to remember. The exemption applies only to investigatory records compiled in the course of specific investigations and that focus on specific individuals and acts. Here, this was about records concerning the use of a breathalyzer. They were exempt only if the documents requested were compiled for law enforcement purposes, and disclosing those would interfere with enforcement proceedings. Law enforcement records are exempt, however, only if their release would also result in the interference with enforcement proceedings or cause one of the other results described in 2-534A3. And here are two cases that are instructive and I would recommend reading. So to get to the exemption, the threshold requirement is to apply the record or information sought has to be compiled for a law enforcement purpose. Now, this is a broad scope, and courts have held that the law enforcement purpose encompasses a wide variety. Records compiled as part of violent investigations or drug trafficking investigations, including the use of informants, have been found to meet that threshold. Records compiled as part of investigations into nonviolent activity, however, have been found to satisfy the threshold as well, as have records used in efforts to prevent wrongful activity. So you go across the spectrum from violence and drug trafficking, undercover work, informants, etc., but also the exemption ends up applying to nonviolent illegal activity and efforts to prevent wrongful activity. Additionally, the courts have found the threshold satisfied for non-investigatory records, provided they involve a law enforcement purpose, such as law enforcement manuals. So again, the exemption would apply even in terms of information pulled in to create a manual, but they've denied the protection when the agency failed to establish a sufficient connection between those records and any law enforcement function. So again, this is a very broad exemption, broadly applied and construed by the courts, but there is, in fact, a requirement to establish sufficient nexus between the records and any law enforcement function. This is a blow up of what we just discussed. I do want to point out, however, here, in the second bullet, courts have denied protection, and a law enforcement agency did not adequately demonstrate that, one, the records were compiled as part of the agency's stated law enforcement purposes and duties, or two, the records existed independently of the stated law enforcement purpose, or three, the connection to law enforcement was pretextual. So again, the court will, in fact, dig on the question of whether the attempt to establish a law enforcement connection is pretext, or four, the associated investigation was conducted for an improper purpose. And, there are cases where, again, the court determined the investigation was improper, therefore the records will end up not in all likelihood being subject to the exemption. DC FOIA seeks to strike a balance for maximum disclosure, even of law enforcement information, but not in cases where the information would endanger people, interfere with due process, or severely hamper law enforcement effort. And this is from the Committee on Judiciary notes at page 7. So here, an example, the MOLC has ruled that investigatory records in a 6-year-old murder case were exempt from disclosure if charges in criminal litigation were still possibilities. So again, even despite that attenuation of time, the MOLC still determined that those records were exempt. The MOLC also held that the privacy interests of police and a crime victim's family militate against releasing a videotaped murder confession that was never admitted into evidence against the accused when the tape was sought by a news reporter. So again, the privacy interests of the police and the crime victim's family, did in fact, to use the quotes word, militate against releasing. MOLC also held that disclosing a police officer's record regarding an investigation into her alleged drug abuse, when no disciplinary charges were brought and absent allegations that the investigation was mishandled, would serve no public purpose. DC FOIA provides that all complaints and other specific police records shall be open for inspection. That's in section 5-113.06, and also you could look under DC FOIA 534C. This section shall not operate to permit non-disclosure information of which disclosure is authorized or mandated by other law. So in this case, there were some 70 police officers, and there was information about criminal charges filed against them, and that was in fact required to be disclosed under 5-113.06, which again, formerly in the code was 4-135. And this relates back to the scandal some 30 years ago of members of the police department and criminal charges that have been filed against them. The law enforcement exemption in terms of personal privacy. You'll recall when we talked about the personal privacy exemption, I said we would be talking further under the law enforcement section. Exemption 3C provides an exemption for disclosure for, quote, investigatory records compiled for law enforcement purposes, including the records of counsel investigations and investigations conducted by the Office of Police Complaints, but only to the extent that the production of such records would, and then we'll jump down to section C, constitute an unwarranted invasion of personal privacy. So while the overall DC FOIA exemption 2 requires that the invasion of privacy be clearly unwarranted, the word clearly doesn't appear under exemption 3C, the law enforcement exemption relating to personal privacy. So the standard here for evaluating a threatened invasion of privacy interests is broader than it is under the full exemption 2 for privacy. And for more on that, you can see US DOJ versus Reporters Committee. So again, when you're dealing with the law enforcement exemption personal privacy, there is a broader application of exemption than there is under the full DC FOIA exemption 2. Records pertaining to investigations conducted by MPD are exempt from disclosure under 3C if the investigations focus on acts that could, if proven, result in civil or criminal sanctions. So from this case, Rural Housing Alliance, the exemption, quote, applies not only to criminal enforcement actions, but to records compiled for civil enforcement purposes as well. And we alluded to that before with the holding from another case that talked about, not just violent and non-violent, but also deterrent and civil enforcement. Determining whether disclosure of a record constitutes an invasion of personal privacy requires a balancing of the individual privacy interest, here's our balancing test in a slightly different form, against the public interest in disclosing the information. Absent substantial allegations of wrongdoing, courts generally recognize that law enforcement personnel have a privacy interest in non-disclosure of their names due to the potential for harassment or embarrassment if their identities are disclosed. See here, we've got Dorset's as well as Abraham and Rose, both non-DC circuit opinions from 20, 30 years ago, where we see that clear privacy interests exist with respect to names, addresses, and other identifying PII information, even if it's already available in other public filings. So the fact that there has been disclosure, unlike, say, the commercial, the trade secret issue, even if this information is available in other public filings, there is still a clear privacy interest with respect to law enforcement names, addresses, and other identifying information. Okay. Agency communication, both inter and intra-agency, memos and letters, and then things related to litigation. So 2-534A4, interagency memos and letters, which covers both within and between agency memorandums or letters generated or received by the staff or members of the council, which would not be available by law to a party in litigation with a public body. So again, that's the standard: within or between correspondence, including memos and letters generated or received by staff of the council or members of the council, which would not be available by law to a party in litigation. Now, within this, we also have the litigation-based exemptions. 2-531A4 provides an exemption from disclosure for privileges which could be asserted during litigation, deliberative process, attorney-client, and work product. Agency communication. So let's talk about these litigation-based privileges. DC FOIA expressly provides that the deliberative process privilege, the attorney work product privilege, and the attorney-client privilege are incorporated into the exemption in 2-534A4. So it's an express incorporation. So there is no essentially room for doubt that these privileges are in fact incorporated. So historically, the bulk has used the common law deliberative process privilege to find that documents are exempt from disclosure using this exemption because they wouldn't be available to a party in litigation with the agency. Let's talk quickly about these three cases. In Shaw Cole redevelopment, this case involved withholding documents related to an executive decision about real estate development. And then Alonzo Williams versus the Office of the Superintendent, concerned withholding memoranda from a hearing examiner whose recommendation was rejected by the superintendent, and that the superintendent was the final arbiter of the decision at issue. And then in reappeal of the ACLU, this was about remanding a case to the DC Department of Corrections to determine whether requested memorandum is part of a pre-decisional and deliberative character. We're going to talk about that. So when does the exemption apply? With this exemption, the record has to be part of the agency's deliberation process, part of the process. So it protects the frank discussion of legal and policy matters, so the agency isn't subject to pressure outside of public opinion. The key test here is three-part. One, is the document a final decision? Two, are they pre-decisional documents or documents that implement or explain the decision? And three, are they communication from the decision maker or to them? So as an example, just to start us off, advice memos do not fall under the exemption if they're final. If they relate to a final decision, see under the key test number 1, they are not under the exemption. But drafts of an advice memo are, because they're viewed as deliberational and pre-decision. So the first question is the document a final decision? Then are they pre-decisional or documents that implement or explain the decision? And then are they communication from the decision maker or to them? As a matter of policy, reports and analyses prepared by an organization outside the government, even if they're used in an agency's deliberative process, do not fall within the exemption. And I'm going to read this quote from Belth v. DCRA from about a quarter century ago. To hold otherwise would be to rule that the independently initiated, prepared, and funded reports of a private organization, which that organization desires to withhold from public scrutiny and discussion, but to have been used by a government agency as the basis for important public policy decisions, would then be immunized from disclosure. So let's talk about Belth here for a moment and explain this part of the holding. So in Belth, an outside agency took publicly available information and on insurance companies, and then prepared reports on that basis, which they then provided to state and municipal regulators of insurance as reference material for their use. And a academic wanted access to these reports with this data, and essentially numerous exemptions were claimed by both the private organization, the public bodies, etc. As and there was an intervener, and the court essentially held that, to go back to this holding, that would be the rule that the independently initiated, meaning this private company did this on its own, the state governments didn't ask them to do this. They independently prepared the information and they funded the reports of a private organization. And that organization, this private company, wants to withhold from public scrutiny and discussion, but it's been used by the insurance regulators as the basis for important public policy decisions. In this case, whether they needed to look into or adjust the regulation on individual insurance companies, would be immunized from disclosure. And clearly, the court held that those exemptions would not cover that, and that disclosure was necessary. Consultants. There is what is known as the consultant corollary doctrine. In some limited circumstances, a non-agency party may act as a consultant to the government, and in those cases, their communications may qualify as an intra-agency exchange for Exemption 4 purposes. This extension of the intra-agency relationship to cover such agency consultants is generally referred to as the consultant corollary or consultant corollary doctrine. The High Court explained the court's rationale in these cases that, quote, the records submitted by outside consultants played essentially the same part in an agency's process of deliberation as documents prepared by the agency's personnel might have done. So the court is essentially saying that though they are an outside consultant, because they are a consultant and because the role of the consultant's recommendation being pre-decision or deliberative as what might have come from an employee of the agency, that would in fact extend in some cases the exemption. In People for the American Way Foundation, the court held exchanges between Department of Ed and the mayor's office related to a federally funded school voucher program were not intra-agency, because the mayor's office advocated on behalf of the interest of its own constituents. And, the court also found there wasn't truly a consultant relationship because USDOE and the mayor's office, they shared responsibility for the DC voucher program. And so the information was not, being conveyed to the Department of Ed to unilaterally make ultimate decisions based on, the mayor's advice, mayor's office's advice, it was, there was a shared responsibility. And, the court noted that its holding was consistent with the fact that there was no precedent for withholding documents under Exemption 5, our case, Exemption 4, where a federal agency and a non-federal entity, such as the mayor's office, share ultimate decision-making authority with respect to a co-regulatory project. So this being DC, there are numerous co-regulatory or co-shared responsibility situations between the federal government and the district. And so here we need to be very aware of the consultant corollary doctrine. So we've talked about the trade secrets, privacy, law enforcement, and agency communication exemptions. Again, the slides are going to be available, as will be the recording. Here are some additional helpful resources that we've identified. Report from the Lawyers Committee for Freedom of the Press, the OIP report, which I mentioned earlier from DOJ, and information on FOIA appeals through the MOLC. So at this point, I'd like to ask if there are any questions. Again, please raise your hand in Teams or put it in the chat. I'll just finish by saying we look forward to seeing everyone at the last 4 of these webinars. The next is on July 11th. Obviously, we're skipping the 4th, and that'll be an update on FOIA litigation. On the 18th, we're going to have categories of FOIA requesters, fees and acknowledgments, and denial letters. On the 25th, FOIA officer reporting duties and searching for electronic records. And then OAG is going to assist us with preparing a FOIA civil case and FOIA defensive litigation. This is us. I'm an attorney advisor. Our director is Mikal Allen. Chief Counsel Barton is here with us today. My 2 attorney colleagues, Cherie DeVary and Nick Weil. Our paralegal is Kimberly Brown, and our IT specialist is Kevin Brown. All great folks who will happily help you, as will I, with anything going forward. And I'm going to stop sharing my screen and thank you all. See, do we have any? Martin, do you see any? I'm not hearing anything.
Your voice went out for a minute, Anthony.
Okay, there we go. Let's check the chat here. Okay, so we're getting some thanks. If there aren't questions, and there don't have to be, I want to thank everyone for attending today. Again, we're here to help and assist any way we can. We look forward to you joining us, not on the 4th. Remember to go enjoy yourself on the 4th, and then see us on the 11th for our next webinar. And in the interim, we will send out a link to the recording for today's presentation, as well as the slides. So with that, if no one has anything else, we'll say good afternoon, and under darkening skies, I hope that everybody stays safe and dry.
Excuse me, are you gonna provide us with the slides?
I'm sorry?
Can you provide us with the slides?
Yes, we will send out an email with a link to both the recording and the slides.
Thank you. You're the best. Okay.
No problem. You bet.
Have a good one.
Thanks, you too. Okay, well, Johnny and I will hang out for a moment. And like I say, if someone has a question they want to stay and ask, otherwise, feel free to go out there and, again, be safe.